I want to speak directly to you, not to gun owners as a broad group, not to young people at a shooting range, not to first-time buyers trying to figure out which firearm to get. I mean you, the person watching this right now who has spent 30, 40, maybe even 50 years being a careful and responsible gun owner. The person who keeps a bolt-action hunting rifle that once belonged to your father. The person who holds onto a revolver your grandfather once carried. The person whose gun safe has sat in the same corner of the same bedroom for 2 decades, with firearms that have been treated with care, stored the right way, and maintained properly every single year without exception. I am speaking to you because the firearms law changes that take effect this July were crafted with a particular type of gun owner in mind, and you are a very different kind of gun owner altogether. That difference has legal significance, it has specific implications, and it is going to affect choices you may already be in the process of making right now. Choices about the firearms you currently own and the people you eventually want to pass them on to. Here's what I mean by that. When most people first caught wind of the new firearms laws set to take effect on July 1st, 2026, the assault weapons clauses, the magazine capacity limits, the updated purchase requirements, they generally landed in one of 2 camps. Either they concluded the new laws applied to them and began worrying, or they concluded the new laws had nothing to do with them and decided to tune it all out completely. Both of those conclusions may be mistaken, because here is the piece that almost no one discussing these July 2026 changes is actually bringing up. The laws include specific exemptions that were deliberately crafted, written with precise language, specifically covering the categories of firearms that seniors like yourself are most likely to have in your possession. Bolt-action rifles, lever-action rifles, revolvers, antique firearms, guns manufactured many decades ago, firearms passed down to you from parents and grandparents. Those exemptions work in your favor, but they do not protect everything without limit, and the boundary between what is protected and what is not, especially for seniors thinking about giving firearms to grandchildren, thinking about estate planning, thinking about what becomes of a lifetime of collected firearms. That boundary shifted on July 1st, and the vast majority of seniors have no awareness that it moved at all. This video is going to show you exactly where that line now falls. Let me walk you through the reasons why July 1st, 2026 carries a particular kind of significance for senior gun owners, one that is meaningfully different from how it affects younger gun owners. The tendency to frame this as a general gun law story has caused most seniors to either spiral into unnecessary worry or dismiss it entirely, when what they actually need is accurate, situation-specific information. Here is the demographic reality. Seniors who came of age in the 1940s, 1950s, and 1960s learned to handle firearms within a specific tradition: hunting, competitive marksmanship, military service, guns handed down through family lines. The firearms sitting in your safe are most likely not the semi-automatic rifles with detachable magazines and pistol grips that the new laws are primarily aimed at. They are more likely bolt-action hunting rifles, lever-action rifles, revolvers, shotguns, and firearms that are several decades old, some of them qualifying as antiques by legal definition. This distinction is critical because the new laws draw a deliberate and specific line between these categories. Virginia's HB 217, the most far-reaching firearms law change going into effect on July 1st, 2026, there explicitly carves out manually operated firearms from its provisions: bolt action, lever action, pump action. These are untouched by the assault weapons sections of the law. They fall outside the magazine capacity restrictions that apply to detachable magazines. They are unaffected by the feature-based criteria used to determine what qualifies as an assault firearm under the new legal standard. For a senior whose collection is made up primarily of these types of firearms, and that accurately describes the majority of senior gun owners I work with, the July 1st changes may not directly limit what you currently have or how you currently hold it. But here is the part that does touch your situation, the part that coverage of these laws has almost completely overlooked. If you have been considering transferring any of your firearms to a son or daughter, to a grandchild, to someone you trust in your life, the rules that govern those transfers changed on July 1st. If you have been thinking about what happens to your firearms once you are no longer here, the estate planning and inheritance framework that determines how your collection reaches your heirs has shifted. And if you have been looking at any purchase at all, including assisting a grandchild with their first firearm purchase, new requirements in several states may now come into play. These are not the questions getting airtime in firearms media right now. That conversation is focused on the AR-15 provisions, magazine limits, and the political back and forth. Nobody is sitting down and asking specifically what July 1st means for a 70-year-old with a bolt-action rifle and a firearms collection he wants his son to inherit. That is exactly the question I am going to address right now. If you want legal education focused specifically on seniors and firearms law at the moment it actually matters, hit subscribe now. Let us walk through exactly what changed and exactly how it affects your situation. Section 1. What the new laws leave untouched, the senior exemption you need to be aware of. I want to start here because this is the single most important thing I can tell a senior gun owner about July 1st, 2026, and it is the piece most seniors have not heard stated clearly. The major firearms law changes taking effect July 1st, specifically Virginia's HB 217, the most significant of the new state-level laws, explicitly exempt manually operated firearms. This means bolt-action rifles, lever-action rifles, and pump-action firearms are not brought under the assault weapons provisions of the new law. Let me read you the actual language from Virginia's HB 217 directly so you hear precisely what it says. The law exempts antique firearms, permanently inoperable guns, and manually operated firearms such as bolt-action or lever-action rifles, bolt-action, lever-action, and antique firearms. If your collection is made up primarily of these firearms, and for most senior gun owners who grew up hunting and who inherited guns from earlier generations, that is exactly the case. The assault weapons provisions of Virginia's new law place no new restrictions on your possession of those firearms. Here is why this matters beyond the surface level. The exemption for manually operated firearms is not simply a narrow technical workaround. It reflects a legislative acknowledgement that the underlying public policy concern driving the new law, semi-automatic firearms with military-style features capable of high-volume rapid-fire is specifically not what bolt-action, lever-action, and manually operated firearms represent. A bolt-action hunting rifle that has been passed through your family for half a century is not the category of firearm these laws were designed to address, and the antique firearms exemption goes even further. A firearm manufactured before 1899 is generally classified as an antique firearm under federal law. Many seniors own firearms that meet this definition: guns inherited from grandparents, guns purchased long ago, firearms that are as much historical artifacts as they are functional weapons. These firearms carry additional exemptions under both federal and state law that are worth understanding thoroughly if any of them are part of your collection. Your action step. This week, go to your gun safe and look at every firearm you own. Determine whether each one is manually operated, bolt action, lever action, or pump action. Determine whether any of them may qualify as antique firearms. For the firearms that fall into those categories, the July 1st assault weapons provisions create no new restrictions on your possession. For any semi-automatic firearm in your collection, keep reading because the analysis is different. Section 2, the grandfather clause and what it actually protects. For seniors who do own semi-automatic firearms or who own magazines capable of holding more than 15 rounds, the grandfather clause in Virginia's new law is the protection that matters most, and it needs to be understood with precision because its coverage is real, but it has limits. Here is what the grandfather clause covers. If you owned a firearm before July 1st, 2026, that would fall under the law's definition of an assault firearm, you are permitted to keep it. The law does not require you to surrender it, destroy it, or register it in most configurations. Your continued possession of a firearm you lawfully owned before July 1st is protected. The same applies to magazines. If you currently own magazines capable of holding more than 15 rounds and you own them before the effective date, you are permitted to keep them. This is meaningful protection for seniors who have owned these firearms for years or even decades. Your collection does not become unlawful overnight simply because of July 1st. But here is where the protection stops. And this is the piece that directly affects seniors who are considering estate planning, gifting, or inheritance. The grandfather clause protects your possession. It does not unconditionally protect transfers. Virginia's HB 217 allows limited categories of transfers for firearms lawfully owned before July 1st, 2026, specifically sales to licensed dealers, inheritance transfers, repairs, and transfers to immediate family members. These limited transfer categories remain available, but a general transfer, giving a grandfathered firearm to a friend, selling it to a private buyer who is not an immediate family member, moving it to someone outside the defined categories, faces new restrictions under the updated legal framework. For a senior who has been planning to give a particular firearm to a grandchild, that transfer may fall within the immediate family member exception, but the precise legal definition of immediate family as the law uses it needs to be verified for your specific circumstances. A grandchild may or may not qualify depending on how the law defines that category and depending on subsequent guidance issued by the Virginia Attorney General's office. Your action step: if you own any semi-automatic firearm in Virginia and you have been planning any kind of transfer to a family member through your estate as a gift or otherwise, pause that plan until you have confirmed the transfer falls into a permitted category under current law in your state. Talk to a Virginia firearms attorney before making that transfer. The permitted transfer categories are specific, and getting it wrong, transferring outside the allowed categories after July 1st, creates legal exposure for both you and the person receiving the firearm. Section 3. Estate Planning and Inheritance. The July 1st issue no one is discussing. This is the section that carries the greatest significance for seniors specifically, and it is the section that has received virtually no attention in the firearms media coverage surrounding the July 1st changes. Here is the core issue. Many seniors have never updated their estate plan to specifically address their firearms collection. They have a will, they may have a trust, but that will or trust was drafted years ago, possibly before some of the firearms they currently own were even purchased, and possibly without any specific direction about how firearms are treated differently from other types of personal property within an estate. July 1st, 2026 changes the legal framework within which your estate will distribute your firearms, specifically your semi-automatic firearms in Virginia and Rhode Island. It does not change what you are currently permitted to own, but it changes what your executor or trustee can legally do with those firearms once you are gone. Here is the specific problem. An executor administering an estate carries a fiduciary obligation to distribute assets in accordance with the law in effect at the time of distribution. If a senior passes away after July 1st, 2026, and their estate includes semi-automatic firearms now subject to transfer restrictions, the executor cannot simply hand those firearms to whoever is named in the will without first confirming that the transfer complies with the new law's permitted transfer categories. An executor who distributes a restricted firearm to a beneficiary who does not fall within the law's permitted transfer categories, even while faithfully carrying out the terms of the will, may be facilitating an unlawful transfer. The solution is not complicated, but it does require action before it becomes a problem. Update your estate plan to specifically address your firearms. Work with an elder law or estate planning attorney who is familiar with your state's current firearms laws as of July 1st, 2026, not as of whenever your current will was originally drafted. Consider establishing a firearms trust if your collection is substantial. A firearms trust provides a clear legal framework for the ownership, use, and transfer of firearms that is specifically constructed to remain compliant with applicable gun laws at every stage of the process. And have the conversation with your intended heirs now while you are present to participate in it, while decisions can be made with your direct input. While the legal planning can happen proactively rather than reactively under the pressure of an estate being administered, your action step: pull out your existing estate planning documents, read whatever section addresses your personal property and specifically your firearms. If there is no dedicated firearms provision, or if the will was drafted before the July 1st changes, schedule an appointment with an estate planning attorney this month. Not because your firearms face any immediate threat, but because the legal framework for transferring them just changed, and your estate plan needs to reflect the current framework, not the one that existed before it. Section 4. Helping grandchildren purchase their first firearm. New requirements. This section speaks to a situation that is extremely common among senior gun owners and that is now subject to updated requirements in several states. Many seniors are the person in the family who introduces the next generation to responsible gun ownership. They accompany grandchildren to purchase a first firearm. They offer guidance on which firearm to choose. They sometimes help financially with the purchase. This is a tradition of mentorship in responsible gun ownership that has been woven into American family culture across generations. Several states have now added steps to this process that seniors assisting grandchildren through a first firearms purchase need to understand. In Colorado, beginning August 1st, 2026, individuals who wish to purchase most specified semi-automatic firearms, including certain rifles and handguns with detachable magazines, must first obtain a firearm safety course eligibility card. To receive the card, the applicant must complete a background check and a state-approved firearm safety course. This means a grandchild in Colorado who wishes to purchase a semi-automatic rifle or a handgun with a detachable magazine after August 1st must complete this process before the purchase can happen. A senior accompanying that grandchild to a gun store in August needs to know that the purchase cannot be completed without the eligibility card, and that obtaining the card requires advanced preparation, including finishing the safety course before visiting the store. In Virginia, the minimum age for purchasing certain categories of firearms has been raised to 21. A grandchild who is 18, 19, or 20 years old, someone who would have been legally permitted to purchase certain firearms in Virginia before July 1st, is no longer eligible to purchase those specific categories after July 1st. Your action step, if you are planning to accompany a grandchild or another young family member to purchase a firearm in the near future, and you live in or plan to make the purchase in Colorado, Virginia, Maryland, or any other state that saw significant legislative activity in 2026, verify the current purchase requirements in that specific state before the visit. The requirements that were in place the last time you helped a family member through this process may no longer apply. Section 5. The 4 things every senior gun owner should do before July 31st. Let me close with a concrete, actionable checklist, because what I want you to take away from this video is not anxiety about what changed, but a clear understanding of what steps to take in response. Action 1. Inventory your collection by firearm type. This week, before anything else, go through every firearm you own and place each one into a category: manually operated, bolt action, lever action, pump action, semi-automatic with a detachable magazine, revolver, shotgun, antique. This inventory immediately shows you which firearms fall clearly into the protected category under the new laws, which fall into the grandfather clause category if you are in Virginia or Rhode Island, and which require additional review. Action 2. Review any planned transfers before moving forward. If you have been planning to give any firearm to a family member as a gift, as part of estate planning, as part of helping a grandchild obtain their first firearm, pause that plan until you have confirmed the transfer falls into a permitted category under current law in your state. This is not a permanent pause, it is a due diligence pause. The majority of transfers seniors are considering fall into exactly the categories the new laws specifically preserve: immediate family transfers, inheritance, gifts to adult children. But confirm before you proceed, not after. Action 3. Update your estate plan to address your firearms directly. If your existing estate planning documents, your will, your trust, do not specifically address your firearms collection with current law reflected, make an appointment to have them updated. This is a single conversation with your estate planning attorney that, once completed, provides a clear legal framework for your entire collection for as long as you own it. Action 4. Talk to your family now. Let your children and grandchildren know what firearms you have, where they are kept, and what your intentions are for them. The combination of sound legal documentation and open family communication is what prevents estate disputes, unintentional legal violations, and the deeply unfortunate situations I have witnessed, where a lifetime of carefully maintained firearms creates legal complications for a family that simply was not prepared for the current legal landscape. Let me bring it all together. If your collection consists primarily of bolt-action rifles, lever-action rifles, revolvers, and antique firearms, the July 1st assault weapons provisions place no new restrictions on your possession of those firearms. The exemptions written into the new laws cover precisely the types of firearms most commonly found in senior collections. If you own semi-automatic firearms that were lawfully purchased before July 1st, 2026, the grandfather clause protects your continued possession of them, but it does not unconditionally protect transfers. Know the permitted transfer categories before you give, sell, or distribute any of those firearms. If you have been considering estate planning for your collection, July 1st change the legal framework your executor will be operating within. Update your estate plan now while you are present to guide the process, rather than leaving that complexity for your family to work through later. If you have been planning to assist a grandchild with purchasing their first firearm, know the current purchase requirements in your state before that visit takes place. Several states have added steps that require advance preparation. And the 4 actions: inventory your collection by type, review plan transfers, update your estate plan, and talk to your family. I opened this video by speaking directly to you, the person who has been a responsible gun owner for 30, 40, or 50 years, the person whose firearms are not data points in a policy debate, but represent a lifetime of responsible ownership, a connection to tradition, and in many cases, a living link to the people who raised you. The laws I have described today do not erase that. They do not confiscate your collection. They do not eliminate your rights, but they do change the framework, specifically in the areas of transfer and estate planning, in ways that call for your attention before those changes produce complications you never saw coming. You have that awareness now. Put it to use. Share this with every senior gun owner you know, especially every senior who has been watching the July 1st coverage and is not sure whether it applies to their situation. Because for most seniors, with the types of firearms most seniors own, the answer is more nuanced and more reassuring than the headlines make it sound. But nuanced and reassuring still requires knowing the specific answer, not simply assuming it. What happens when you want to formally transfer a bolt-action or lever-action rifle to a grandchild and you want to make sure the paperwork is handled correctly, including through an FFL if required, with proper documentation for your estate? Check out the next video where I walk through the complete legal process for transferring firearms between generations, from documentation to FFL involvement to full estate planning integration. I will see you there.